Kaduna, please unmute your mic.
Yes. His mic is on mute, please. His mic is on mute. Kaduna, you're on mute. Can you unmute? Yes. Is it okay now? Yeah, it's okay. I can hear you now. Can you call the case?
Yes. Okay. Case number 1.
Yes.
Case number 1, NICS/KD/17/2017 between Peter Andrew and United Healthcare International Limited. My lord, the claimant is present. Defendant absent.
Claimant present. Defendant absent. Appearances, please.
With humility, my lord. PG Serki.
Yes.
My humble appearance is for the claimant.
Yes. Any appearance for the defendant, please?
Not represented, my lord.
No legal representation for the defendant.
Yes, my lord.
Yes, judgment. The claimant at all times must. Yes, I'm on it. Judgment. The claimant at all times material to the suit was an executive officer of the defendant. His contention is that the defendant failed and or refused to pay his salary and terminal benefits after his appointment was terminated. On the premises of this briefly summarized fact, the claimant by his complaint and statement of facts filed on the 6th of May 2019 claimed against the defendant as stated on the face of the judgment. To save the time of the court will skip that aspect. In the statement of defense deemed filed on the 27th of January 2021, the defendant joined issues with the claimant by denying the entirety of his claim. The defendant contended in summary that the termination of the claimant's appointment was due to abandonment of duty for more than 7 days without the approval of the management, and the claimant was subsequently dismissed. As such, he is not entitled to the salaries and terminal entitlements as claimed. The claimant's reply to the statement of defense was filed on the 4th of February 2020. At the plenary trial, the claimant testified for himself and called no witness. He adopted his statements on oath as his evidence in support of the documents whilst examination, after which his case was closed. The defendant in turn called one witness by name Jennifer Oagbo, the acting head of human resources of the defendant. She equally adopted a statement on oath and tendered 7 sets of documents as exhibits. At the close of courts to file their final written addresses as prescribed by the provisions of Order 45 of the rules of this court. In the defendant's final address, settled by S.O. Yahya, Esquire of Council, filed on 21st of June 2021, and pursuant to Order 45, Rule 7 of the rules of this court, was deemed properly adopted on the 27th of January 2022. Two issues were identified as having a reason for determining the previous case on the preponderance of evidence to be entitled to the relief sought in the complaint. And 2, whether the claimant's suit before this honorable court has reasonable cause of action that will make him to be entitled to all the relief sought. In the final address, deemed properly filed on the 13th, Learned Counsel P.G. Serki, Esquire, also formulated 2 issues as having a reason for determination in this suit as follows. 1, whether the decision of the defendant to summarily terminate the claimant from his employment without giving him a hearing does not contained under Section 36 sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended, as well as breach of defendant's condition of service. And 2, whether the claimant, having not been properly relieved of his appointment in line with the terms of contract, is not entitled to reliefs claimed in paragraph 26 sub 1 to 4 of Statement of Facts. In order to resolve the conflict that has arisen between the parties on basis of the admissible evidence on record, the reliefs claimed, and in consideration of the applicable legal principles, I shall adopt each one as framed by the defendant's learned counsel, considered the totality in defendant's written final or specific reference to arguments conversed in the final submission as it is considered needful in the course of this judgment. The claimant testified that he was in the employment of the defendant as a marketing officer until his appointment was terminated on 10th of May 2017. According to him, sometime in March 2017, the defendants granted him approval to proceed on annual leave. That while he was on his annual leave, the defendant sent a message on his cellular phone recalling him to report for duties. That the message was not received until the following day because his official phone line had been switched off since it was not charged. That he informed the defendant of his inability to report to the office as instructed because the message was received late. That the defendant served him a query which he promptly replied, and that on the 10th of May 2017, the defendant sent an electronic mail to him conveying a letter terminating his appointment effective from 2nd May 2017. The claimant testified further that he had served the defendant for 6 years and as such qualified for gratuity as contained in the terms of condition of his employment. The claimant also testified that his appointment was terminated and not dismissed, and therefore entitled to 1 month's salary in lieu of notice, and that is claimed for outstanding salary for the months of April till 10th May 2017 was denied by the defendants in the reply to the letter of demand. In further support of his case, the following documents, namely letter of offer of appointment, letter of confirmation of appointment, letter of promotion, application for care loan, memo of defendant approval of annual leave, reply of query, handover note, letter of termination of appointment attached to electronic mail, solicitor's letter of demand, defendant's reply to letter of demand, defendant's employee handbook, staff register were admitted in evidence as Exhibit C1, Exhibit C2, Exhibit C3 to C3A, Exhibit C4 to C4A, Exhibit C6 to C6A, Exhibit C5, Exhibit C7, Exhibit C8, Exhibit C9, and Exhibit C10, respectively. The defense put forward by DW1 as it is material to the issues under resolution is that there had been complaints of absence from duty against the claimant prior to the approval of his annual leave, and that based on the complaints, the management of the defendant recalled the claimant from his annual leave through text messages on his mobile cellular phones, but that the claimant deliberately refused to honor the instruction to resume duties. DW1 testified further that in failing to honor the instructions sent through the text message, the claimant was not available to defend the allegation of absconding made against him, that a query was issued, but the claimant did not advance convincing reason in his reply to the query, and on the 3rd of May 2017, the management through an electronic mail terminated his appointment. DW1's further testimony is that the claimant's appointment was subsequently dismissed through an electronic mail of 10th May 2017. The defendants maintained that the claimant is not entitled to gratuity because he was dismissed, and further contends that the claimant is indebted to the defendant for the balance of care loan advanced to him. The following documents were admitted in evidence to further buttress the case of the defense. 1, query to claimant as Exhibit D1. 2, claimant's reply to query as Exhibit D2, letter of termination of appointment as Exhibit D3, electronic mails without attachment as Exhibit D to D4A, defendant's reply to claimant's letter of demand, Exhibit D5, defendant's handbook, Exhibit D6. Now, the claimant's claim as stated in Relief 5 of his claim is for damages for unlawful termination of his appointment. It is tried that where an employee alleges wrongful termination or dismissal, the onus is for him to prove the allegation. In addition, it is also important to plead all relevant facts and materials upon which to hinge claimant's claim to sustain his allegation. Having done this, the claimant is next required to adduce credible evidence in proof of the pleaded facts. See the cases of Port Oil PLC versus Ogungbemile and the case of Union Bank of Nigeria PLC versus Toyibo, citation supplied. Arising from this point of law, I have carefully examined the pleaded facts and evidence adduced by the claimant. It is significant to remark that the bone of contention against the defendant is the non-payment of the salary and terminal entitlement, and the facts were not pleaded or evidence was adduced by the claimant on the allegation of wrongful termination or dismissal of his appointment to support his claims for damages for unlawful or wrongful termination of his appointment. I should also note that learned claimant's counsel made attempts in his written address to introduce facts on the violation of the right of fair hearing and breach of condition of service by the defendants, which facts were not pleaded in the statement of facts. It is trite and elementary to restate that address of counsel, no matter how brilliant, how eloquent, how erudite or articulate, cannot take the place of evidence. The address of counsel, which is only intended to assist the court, cannot be in vacuum or suspended in the air, but must be placed on pleadings or evidence to show it. It's, in other words, address of counsel not based on pleadings and evidence is inconsequential and goes to no issue. It has no probative value and not what a dime in the scale of evidence for consideration by the courts. See the cases of BFI Group Corporation versus Bureau of Public Enterprise, Amidu and another versus Kaduna Electric Distribution Company, citation supplied. There being no pleadings or evidence of violation of fair hearing and or breach of condition of service or proof of wrongful termination of his appointment, I hereby discountenance the entirety of the learned claimant's counsel's arguments and submission on the violation of the right of the claimants to fair hearing, breach of the condition of service and or wrongful termination of appointment by the defendant. The claim for damages for unlawful termination of the claimant's appointment failed as same was not proved, and I so hold. The disputes between the parties in the main is the determination of the mode of disengagement of the claimant, and when determined, whether the claimant is entitled to termination and entitlement as claimed. The testimony of the claimant is that the staff book, that is Exhibit C9 or D6, regulated his employment, that his appointment was terminated by the defendant after serving for more than 5 years, that since he was not dismissed, he is entitled to 1 month's salary in lieu of notice and gratuity as provided by the staff handbook. The defendant stands through DW1 on the other end is that a query for absconding from duties was issued and served on the claimant, that not being convinced or satisfied with the claimant's reply to the query, the defendant terminated his appointment on the 3rd of May 2017 and subsequently dismissed him via an email on the 10th of May 2017. The defendant maintained that having been dismissed from his employment, the claimant is not entitled to his claim. The disputes between the parties having been clearly identified in the foregoing, I now turn to examine the terms and conditions applicable to the claimant's contracts of employment in relation to disengagement and terminal entitlement. The first port of call is Exhibit C1, Letter of Offer of Appointment. The contents thereof revealed the terms of the contracts of employment. With reference to termination and dismissal, it states as follows, I quote, termination. This contract may be terminated by either party given 1 month's notice in writing or paying forfeiting 1 month's basic salary in lieu of notice. However, you may be summarily dismissed if found guilty of grave misconduct convicted of a criminal offense, disclose confidential information, or conduct yourself in such a manner detrimental to the company's corporate image. End of quote. It is settled that in determining the mode or manner in which employment contract was determined, the letter issued to the claimant is the proper document to aid the court. Exhibit C5, also admitted as Exhibit D3, is the document by which the claimant's employment was determined. It is dated 3rd May 2017, and captioned termination of appointment. A portion of the exhibits states as follows, I quote,
Yes, ma'am.
I wish to inform you that the management found your reply to the query unsatisfactory and has approved the termination of your appointment as marketing officer with effect from 2nd May 2017 due to abandonment of duty for more than 7 days without any approval from the management. End of quote. Mr. Oyebanji, you are distracting the court. I can hear you clearly from here. Please lower down your tone there. As correctly submitted by the learned defendants counsel, the onus of proof lies on the claimant to satisfy the court that he is entitled to his claims based on evidence called by him to support his claim. Section 131 and 133 of the Evidence Act 2011. It is also provided in Section 136 of the Evidence Act, supra, that the burden of proof as to any particular fact lies on the person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular person. The burden may in the course of a case be shifted from one side to the other. Those provisions of the Evidence Act have been considered by the courts in a plethora of authorities. See the cases of Honorable versus Umba, Intuama versus Akpeme, and Zemba versus Ibeneme, and another citation supplied. It is clear from the above authorities and the plethora of cases on the burden of proof that in order to discover where the burden of proof lies in a civil case, the court has the duty to peruse the entire pleadings of both parties. It is also the consensus of the case authorities that in civil cases, the burden of proof initially lies on the claimant. In other words, in civil cases, the claimant has the initial burden to lead evidence to prove his assertion, but the burden of proof is not static. Once the claimant establishes a prima facie case, the burden of leading evidence in rebuttal shifts on the defendant and vice versa. The arguments of learned defendants counsel is that by the provision of paragraph 712 sub 2 of Exhibit D6, the defendant's handbook, the claimant is not entitled to his claims having been dismissed by the defendant. The defendant admitted that the letter of termination of appointment was sent to the claimant via an electronic mail, but stated further that the claimant was subsequently dismissed on the 10th of May 2017 after his appointment was terminated. While answering questions under cross-examination, DW1 testified further as follows, I quote, the defendant's policy does not require issuance of a month's notice in cases of dismissal. It is true that there are two letters, termination and dismissal. There was no notice issued for the termination because it was dismissed after a week, end of quote. Going further, it was categorically stated in paragraph 3 of Exhibit C8 and D5, the defendant's reply to the claimant's letter of demand, that the claimant is contended that the claimant is contended with the termination of his appointment and was further stated in item 3 at page 2 of the said exhibit that claimant's job was terminated. However, in item 4 at page 2 of the same exhibit, the defendant stated by the provision of paragraph 712(2) of the defendant's handbook, the claimant is not entitled to gratuity having been dismissed on account of abandonment of duty. It is apt at the stage to make a distinction between termination and dismissal of appointment. In both cases of termination and dismissal, the employment of an employee is brought to an abrupt end, albeit with varying consequences. Where a contract of employment is terminated, simpliciter, the employee is accorded the privilege of receiving the terminal benefits provided for under the terms of contract of employment thereof. Characteristically, the right to terminate a contract of employment is mutually inclusive, since either party may exercise it at will. Conversely, dismissal of an employment more often than not results in a loss of terminal benefits, and it equally carries an unpleasant opprobrium to the employee. See the cases of Jumbo versus Petroleum Equalization Fund Management Board, Bank of Agriculture versus Godi, citation supplied. I have considered the oral and documentary evidence by contending parties. In justifying the dismissal of the claimant, the defendant acted on the employee handbook, Exhibit C9D6, by which it is empowered to sanction an employee guilty of serious misconduct. I should remark that the sanction or penalty for abandonment of duty, as stated in item 19 at page 46, is termination or dismissal, not the two. The unequivocal finding of the court is that the claimant has essentially established a prima facie evidence by placing in evidence Exhibit C3 and C7 that his employment was determined by termination of appointment and not dismissal as alleged by the defendant. Therefore, the burden shifts to the defendant to prove by placing documentary evidence that the claimant was dismissed as alleged. Apart from making reference to the provision of paragraph 712(2) of Exhibit C9D6, the defendant failed to discharge the burden of proof that shifted to it, and I so hold.
As the court pleases.
On the basis of the overwhelming oral and documentary evidence on record as analyzed on the foregoing, I must reject the testimony of the GW1 that the claimant was subsequently dismissed after the termination of his appointment. Apart from the fact that the testimony of defendants is a bare assertion that is not supported by any concrete evidence, I believe the plausible testimony of the claimant, which is supported by documentary evidence of the letter of termination of appointment and a solicitor letter of demand for his terminal benefits, that is Exhibit C5 and C7, that on the 10th of May, he received a mail and the letter of termination dated 3rd May was attached to the mail. In totality, the finding of the court is that the mode of determination of the claimant's employment with the defendant was termination and not dismissal, and I so further hold.
As the court pleases.
Now, having held that the claimant's appointment was terminated, as this satisfactorily established his entitlement to his claims for salaries and gratuity, Exhibit C1 and C9 were admitted in evidence to buttress the claimant's claim for 1 month's salary in lieu of notice and gratuity. In further defense of the claim, DW1 testified that the claimant obtained a car loan from the defendant, that he has an outstanding balance of 140,000 to pay on the car loan, and the sum of 53,000 being a salary for April 2017 was used to offset part of the car loan, leaving an outstanding sum of 87,451 naira 73 kobo. Parties are on common ground on this fact. The claimant admitted that a car loan was advanced to him by the defendant and further stated in evidence Exhibit C4, the application and loan agreement. It is now a settled position of law with statutory backing and a legion of decided authorities that what is admitted needs no further proof. By Section 123 of the Evidence Act 2011, no facts needs to be proved in any civil proceedings which the parties to the proceedings or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule or pleading in force at the time they are deemed to have admitted their pleadings, provided that the court may in its discretion require the facts to be proved otherwise than by such admission. There are too many decided cases on this principle. See Akilagun versus Oshobaja, Alaji Indayako versus Dantoro, and 6 others, citations supplied. It is equally an elementary principle of law and indeed well settled. The parties are generally bound by the terms and conditions of an agreement which they voluntarily entered into. It is also tried that the courts are bound by the terms of an agreement which parties before it have freely and validly executed. Thus, if a court is called upon to construe an agreement, the court cannot but limit itself to its express terms of the agreement as indicated and or specified by the parties. This is because where the parties have embodied the terms of their contracts in a written document, extrinsic evidence is not admissible to add, vary, subtract from, or contradict the written terms of the contract or agreement. Therefore, where a court is faced with a task of interpreting a written instruction or agreement from one party to the other, or between 2 or more parties, as the case may be, it is expected that it will carry out its duty within the walls or confines of the written or express terms of the instruction or agreement. See the cases of Babatunde and another versus Bank of North Limited and others, in Chuku and another versus Chuku and others, citation supplied. I had undertaken a careful review of the requirements and essential documents. I had undertaken a careful review of the requirements and essential documentation after the approval of CALON as contained in paragraph 8.3b, item 5 of Exhibit C9 and D6. It states inter alia as follows. C, quote, originals of the vehicle particulars will be kept by the company. The documents shall be made available to the staff upon full payment of the loan. D, in the event of default, the guarantor shall be held liable for the net outstanding loan balance. End of quote. The terms of agreement between the parties is clear, unequivocal, and binding on the parties. It states that the vehicle particulars will be kept by the company until full payment. In the circumstances, therefore, by the terms agreed, the outstanding balance of the claimant's car loan is to be made by the claimants, is to be made by his guarantor. Upon termination of the claimant's appointment by the defendant, the claimant is therefore entitled to his claims for salary for April 2017, 1 month salary in lieu of notice, and gratuity as claimed, and I so hold. On relief 2 for claim for 10 days salary for May 2017, the evidence on record is that the effective date of the termination of the claimant's appointment was from 2nd of May 2017, even though the letter of termination appointment was received on 10th May 2017. Therefore, the claimant's claim for relief 2 fails. I so further hold. In totality, I hold that the claimant has reasonable course of action and adjudges the claim of the claimant for the avoidance of doubts and abundance of clarity. Judgment is hereby entered in favor of the claimant in part against the defendant upon the terms set out as follows. 1, the defendant is hereby ordered to pay to the claimant forthwith the of 625,346 kobo. Salary for April 2017 in the sum of 53,451 naira 73 kobo. B, 1 month salary in lieu of notice in the sum of 53,451 naira 73 kobo. C, gratuity in the sum of 518,000 for 9% of claimants slide by 6 years of service. Parties shall bear their respective costs. This is the judgment of the court. Yes, can we have the next case? Well, we find ourselves in this. Yes, I said we find ourselves in this situation in the country where I cannot come over. So, but I will try and ensure that the judgment is sent either through scanning. So you can obtain the copies if you wish to. Can we have the next case?
Case number 2, NICN/K/21/2021 between Mr. Titus Matthew and Monacat Limited. My Lord, Spanish Ambulance.
Respectfully, my lord. I should just stop. Respectfully, my lord. Merci, Umar.
Did you say the parties are absent?
Yes, parties are absent, my lord.
Okay, merci. Okay, merci.
For the claimant, my lord. Yes, my lord.
Representation for the claimant?
Yes, my lord.
Respectfully,
Any
my lord.
representation
Bukola Ajao.
for the, yes?
Bukola Ajao for the defendant.
Yes, Bukola Ajao for the defendants. Yes.
Yes, my lord. The matter comes up
Yes.
this morning for a report of settlement or hearing.
Mercy Umar.
Yes, my lord.
Yes.
My lord, the matter comes up this morning for report of settlement or hearing, and my lord, parties have settled, my lord.
Yeah, I heard you. So you continue.
Okay, my lord. So we filed terms of settlement.
Yes.
We
When
adopt.
was it filed?
It was filed
When
this
was the
morning.
terms filed?
It was filed this morning, my lord, 4th April 2022.
Yes.
Yes, my lord. We have filed the terms of
The
settlement.
set terms, I can see that the parties resolved to settle and collect the sum 200,000 for full and final settlement of all the claims.
Yes, my lord.
Is it 200,000 naira?
250,
for
250,000
final settlement?
250,000.
Yeah.
Yes,
Because
my lord.
okay. 250,000 as
Yes, my
full
lord.
and final settlement.
Yes, my lord.
You said 250,000 as full and final settlement.
Yes, my lord.
Thank you. So you want the court to adopt same?
Yes, my lord, as consent judgment.
Yes, Mrs. Ajam.
Yes, my lord, that's the position. We adopt the terms as consent judgment in this matter.
Courts parties have filed terms of settlement on the 4th of April 2022. The court hereby enters consent judgment as agreed by parties.
As court pleases.
So grateful, my lord.
I'm also black.
Thank you. Yes, the next case.
Okay.
Parties absent. Appearances, please. Appearances.
Well, we didn't hear the name of the case that was called.
This is Isaac, can you call the case again? I think this is the 41-2020. Is this 41-2020?
It's 39-2020.
39-2020.
Yes, my lord. Parties absent, my lord.
Parties absent. Appearances, please.
With utmost reverence, HT Oyebanji for the claimant.
Yes.
My lord, the matter was dated today for our motion dated the 1st day of February 2022, wherein we're seeking an order of this honorary court enlarging time for the applicant.
No representation for the defendants, Mr. Oyebanji.
No representation.
Yeah, it's for your motion for extension to file extension of time within which to file your written address.
Yes, my lord.
When was the motion filed?
It was filed on the first day of February 2022. May I humbly move in terms of the said motion and urge your lordship to grant the said
Same
application?
has been served on the defendant.
Yes, my lord.
Same was served on the defendant.
Yes, my lord. Same has been served, equally with the final written address.
Yes.
We urge your lordship to grant the said application.
Yes, courts, application granted. Time is hereby enlarged within which the claimant may file his written address. He already filed and served, addressed, is deemed as properly filed and served.
That's the court, please. My lord, the matter was stated today for the motion and said adoption. I don't know if we can proceed with the
case is
adoption of the said
adjourned.
address.
No, I cannot. Is it, we are just deeming it as properly filed and so time if they need to do that. So I'll just give you another date.
As a court, please.
They have how many days to respond? 21 days.
21 days.
Unfortunately, I cannot adopt in May because if I adopt in May, the judgment of Mr. Oye.
My lord made her point very clear as of the last
Are we
time.
together? I
Yes,
said,
my lord.
unfortunately, I cannot adopt in May because the June date.
As a court, please. My lord made her point the last time.
Are you not lucky that I even brought you? I brought you.
I said my
Sorry,
lord
I
made
didn't hear
her
that.
point the last time that it should be till June.
So why are you now pretending and telling me that I should adopt today?
Well, that's what the notice said, that it's for motion and adoption.
So it will be adjourned till the 21st of case is adjourned to the 21st of June, 2022 for adoption.
I apologize for disrupting my lord's ruling proceedings earlier on. I was before Helena brother in Kano.
Okay, thank you. It's okay.
Have a nice day, my lord.
Hearing notice shall be issued and served on the defendant.
As a clerk, please.
Proof of same shall be kept in court file. Yes, the next case, please.
Case number 4, NIPN/KD/41/2020 between the Cobra Ogedengbe and Ogedengbe Ephraim and Nigeria Army and one other.
Defendant and representing yes.
Defendant is represented by
Lieutenant Fakai. FK.
Can you spell it, learned counsel?
FK. That is HJ Fakai. HJ Fakai. Fakai is spelled FK.
FK.
Yes. AI. FK.
Yes. What's his designation?
It's Lieutenant Fakai.
I know he's lieutenant. What is his designation with it? What is his position?
What is your position? SO2 admin. Staff officer. Staff officer admin.
Okay, appearances, please.
Respectfully, my lord, PV Agba is my name.
PV Agba, AGBA.
Yes, my lord.
Yes, sir.
My lord, yes. I appear with NH Longpo.
You have to spell that. NH.
That's are the initials. NH are the initials. Longpo is NOLONGPOE.
Okay.
And
yes.
And MG Audu.
Audu.
Yes, my lord. For the defendants.
Yes.
Yes, my lord. The case ordinarily comes out today for address. But
yes.
My lord, we have filed a motion on notice, which is dated the 4th day of April. That means it was filed today.
For extension of time to file your memo.
Yes, my lord. And the claimant respondent is not on notice. Because, my lord, we received the brief late. It was on Friday that we received this brief.
Yes.
Well, so in the circumstance, you'll be asking for another date.
So you will not be able to move move your motion.
It's on notice. I don't know whether the other party will want to respond to it because he has not been served.
I said to enable you move your motion.
Yes. Yes, that is the position, my lord. Okay.
I'm sure you know that you are paying a lot of default fees if this motion is granted.
We are aware of that, my lord.
Very well.
And my lord, just off the record, why this case was filed, we have been in contact with the claimant, and from our brief with him, from our discussion with the claimant, he instructed the counsel to discontinue this matter. But he even showed us the process that was filed in respect to, prepared in respect to that, but it has not been filed before this court. So I'm just informing the court of our efforts to even do away with this matter.
Okay, until then, when I get the process, I will.
As
I
a
will do the
complice, I'm
needful.
just informing the court of the efforts.
Yeah,
so
it's
far.
good.
Thank you, my lord.
Okay. So in the meanwhile, the case is adjourned to the 11th of May, 2022 for hearing.
As accomplices, I'm very grateful, my lord.
Sorry, I didn't make an order. You said as the court pleases.
Okay, so you said for hearing.
we cannot take it until the other person comes.
Yes.
Case is adjourned to 11/05/2022 for hearing.
As accomplices.
Hearing notice shall be issued and served on the claimant.
As accomplices. We're grateful.
Thank you.
You too.
Hopefully, we hope the situation in the country will be better.
Amen. And big amen to that, my lord. Thank you.
Yes, the court will rise. Yes.